Welcome to Into the Woods, the podcast that takes you through a variety of legal topics of interest, where we explore both the forest and the trees.
So this type of trust is a supplemental needs trust. So the purpose of it is to have those funds in the trust supplement the lifestyle of the beneficiary. So it can be used for all sorts of things that, beyond just the care that the beneficiary might be receiving those government benefits for. So for example, it could be going out to nice dinners, self-care, going on vacation, anything that's kind of above and beyond kind of like a nice benefit that the government benefits are not necessarily designed to provide for.
Many of us have loved ones in our lives who are experiencing a disability or hardship of some kind, which results in them receiving government benefits. In the context of estate planning, those benefits can be disrupted if proper planning is not in place. A supplemental needs trust, also known as a special needs trust or SNT for short, is a very important tool for making sure our loved ones do not fall into this trap. I am David Shaffer, chair of the Family Wealth and Estate Planning Group at Woods Oviatt Gilman. Today, attorney Hannah Cannon joins me to educate our listeners on this topic, including the do's, don'ts, and everything in between with regard to supplemental needs trusts. This is part one of a two-part series devoted to supplemental needs trusts. Hi, Hannah. Welcome back.
Hi, Dave.
So today's topic, supplemental needs trusts. I think before we delve into that topic in great detail, it's important to acknowledge that not all disabilities are the same, and neither are the government benefits that go with them. So in terms of disabilities and benefits, we are not going to explore all of those in today's podcast, but we are going to talk a little bit about the means-tested benefits. And when I say means-tested, Hannah, can you just illuminate that for our listeners?
Yeah, absolutely. Like you said, there's a lot of different types of government benefits, and this area of law is very complicated in a lot of different ways. But specifically means-tested benefits and the types of benefits that these trusts are established to protect generally have to do with the amount of resources or assets available to a beneficiary or an individual with disabilities who is, receiving money from the government because they are under a certain resource level.
So if I have, let's just give a very basic example. If I have $100,000 in the bank account and I'm trying to apply for a means-tested program like Medicaid, for example, I probably will not qualify.
Correct.
Okay.
Yes.
So if I'm under that threshold, let's say I only have 5,000, but you're my aunt and you're very kind and generous, and in your will, you're saying, David, I'm going to leave you $100,000. Now I might have a problem.
Exactly.
Okay.
Yes.
So let's address that. Let's flesh that out and set the stage. If a loved one comes into the office, not your loved one, if a loved one of someone else comes into the office, Hannah, and says, Hannah, you're a great estates attorney. I know you're going to do a wonderful will for me. Here's all the people I want to leave money to, but one of them has cerebral palsy. What should I do? Should I just cut them out of the will because it's too complicated? What are our general recommendations? What's kind of the old school way of thinking, and what's the more modern way of doing it?
Yeah. So I think the old school way of thinking is, okay, this beneficiary or person that I have in my life that I want to provide for after I pass away, or in some way, maybe during my life, is the recipient of a means-tested government benefit, which means they can't have more than X amount of money in their name. So I'm not going to give them anything. I'm going to leave everything to maybe their siblings or my other beneficiaries. They know that I love them. I wish I could leave them something, but I don't want to have to leave them something and then ruin the government benefits that they're receiving or make them ineligible for some of these programs.
I've got to interrupt you. We've got a great show and tell segment coming later that's going to explore why that can be very problematic. But what's the better way of doing it?
Yeah. So the better way is still providing for them, but putting it in a supplemental needs trust. So kind of the focus of this episode is a trust that you can establish for the benefit of these individuals who might be receiving a means-tested government benefit of some kind, which will allow you to leave assets to them and still benefit them in your estate plan or lifetime gifting, that will allow them to use that money for things that they need, but without disqualifying them for the benefits that they are receiving. Because it's held in this special type of trust, they are not disqualified from the means-tested government benefits that they might be already receiving.
So the purpose of this episode is not to go in depth on all of the aspects of a trust, but a trust is a separate entity, right, Hannah? And there has to be someone in charge of it, a trustee, which we'll talk a little bit about later. But once the trust is funded, so let's say my aunt leaves me the money in trust for my benefit, what types of things can the trust be used for without jeopardizing my government benefits?
Yeah, that's a great question. So it's right there in the name. So this type of trust is a supplemental needs trust. So the purpose of it is to have those funds in the trust supplement the lifestyle of the beneficiary. So it can be used for all sorts of things that, beyond just the care that the beneficiary might be receiving those government benefits for. So, for example, it could be going out to nice dinners, self-care, going on vacation, anything that's kind of above and beyond kind of like a nice benefit that the government benefits are not necessarily designed to provide for.
I've even had clients with loved ones with disabilities that have taken Disney vacations, and the government benefits oftentimes allow for one caretaker to accompany the disabled individual on that Disney vacation and pay for that one caretaker as well as the beneficiary from the trust. Now, obviously, you can't take it to the nth degree and have a 10-person family going on vacation with the SNT covering the bill. That doesn't work, but vacations are allowed, and I just wanted to highlight that part. Okay, great. So if there's a will, you've convinced the client not to cut out their loved one. They set up the supplemental needs trust under the will. X amount of dollars is going into that trust. What about like a retirement account, a life insurance policy? How does that interplay with the will? And when we're talking about supplemental needs trust, what should we be aware of?
That's a great question. So this comes into play pretty much in every estate planning case, but it's especially important when we are dealing with a beneficiary who might be disabled or have need for a supplemental needs trust. And the important thing to remember is that your will only controls assets that essentially don't say what happens to them after you pass away. So this would be any asset that does not have a joint owner or a beneficiary on it. So to the extent that there is a beneficiary designated asset, like an IRA that says, when I pass away, everything to my spouse, or contingent beneficiary to my children, those beneficiary designations need to be updated in order to preserve the plan that you're putting in place for this disabled beneficiary. Because without updating those beneficiary designations, you kind of undo everything that you had set up in your will. So for example, you have the perfect will, have an SNT for the disabled beneficiary, but your IRA might give everything to, your 3 children equally, even though one of those children does have a disability. If that's the case, then the IRA will go directly in the name of the disabled beneficiary and could harm the government benefits that they're receiving. So it's really important to update those beneficiary designations and say, in equal shares to these 2 children plus the trustee named in my will. That way it ensures that the share of that beneficiary designated asset ends up in the trust that was created under your will.
Now, because you did such an excellent job as an attorney with mom and dad, and they're convinced, change their will, change their beneficiary designations, everything in line, but all of a sudden grandma and grandpa want to leave money to their grandson who has this special needs trust. What needs to happen in terms of coordination with grandma and grandpa, recognizing you can only control so much?
Yeah, definitely communicate with grandma and grandpa and any other family members that might also want to benefit this individual, and make sure that they are aware that a supplemental needs trust is the way to do that. And maybe just let them know, I'm setting one up under my will. If you want to set one up under your will, those trusts can be combined, and kind of have one trust for that disabled beneficiary. So kind of the same thing. We don't want mom and dad to do all this great work ensuring that this trust is available and the beneficiary is still eligible for the benefits they're receiving from the government, and then have an aunt or uncle or grandma or grandpa then just leave everything outright to them and still jeopardize at that point.
This is a two-part episode, as I mentioned earlier, and I just want to tease a little bit that in the next episode, not only are we going to cover the difference between a first and third party supplemental needs trust, but also gifting. So we've talked about a will and a beneficiary designation in terms of how you leave money to a disabled beneficiaries at death. But what if grandma and grandpa want to give Junior $50,000 right now? How does that work? Obviously, they're still alive, so the will's not going to take effect yet. So a little bit of a teaser. We're going to delve into that in more detail in the next episode, where we talk about third-party supplemental needs trust that can be created now instead of waiting until somebody passes away. The other point I wanted to mention is trustee. You can imagine the importance of the trustee of this type of trust. Someone who's receiving government benefits, there's certain rules and restrictions where the trustee has to adhere to them, or even with the trust, the beneficiary's benefits could be jeopardized, right? We're going to delve into trustee, naming the right trustee, who that might be, and what are the do's and don'ts. So stay tuned in part 2 for that. I do want to pivot quickly to the idea. We've so far talked more about Junior or the grandson, someone maybe who's in their 20s, 30s, 40s. But how do supplemental needs trusts apply to people as they age, and even someone who, quote unquote, doesn't have what most people think of as special needs, but perhaps is a little bit older? How does that apply in this context, Hannah?
Yeah. So back to the point that was raised at the beginning of the episode, the types of government benefits that people receive are very vast. There's a lot of different options and a lot of different people who qualify for them for one reason or another. And I know there's been a few podcast episodes on this, but Medicaid planning for aging individuals is also something that, we deal with a lot in our practice, but something important to keep in mind. And one thing how SNT ties in with this is maybe we see a husband and wife that are older. Maybe husband has to go into a nursing home for one reason or another. We work on qualifying him for Medicaid, making him eligible. And at the same time, we also want to be thinking about, okay, what about wife's estate plan? Wife wants to give everything to husband after she passes away, but husband might be on Medicaid at that point. And that is a means-tested government program where he has to remain under a certain resource allowance to remain eligible for Medicaid. So an SNT can come into play in that situation as well. Maybe we're updating wife's estate plan to say everything that we leave to husband is in an SNT for his benefit. So again, it's still there. He can use it. The funds are available to supplement his life and vacation and nice dinners and everything that we talked about earlier. So we have to do that in case something happens to wife. We don't want everything that she owns to then be back in husband's name, disqualifying him for Medicaid.
And that's critical, right? Because chances are husband and wife, maybe they had wills from 30 years ago that left everything to each other. Sometimes we call them sweetheart wills or I love you wills. But in this case, that could be very detrimental to the overall Medicaid plan. Mm-hmm. So that's important. That makes sense. Okay, show and tell. We teased it earlier. We're back to the court. Seems like we're always talking about court cases in these segments. Not always, but sometimes when we're not talking about Taylor Swift. This is a California court case from 2013. And earlier, Hannah, you alluded to this idea that the old school way was to say, well, if I have a disabled special needs child, we'll just cut her out and her siblings will take care of her and make sure she's all good. Well, that backfired here. And otherwise it wouldn't be a court case, right? If it didn't backfire. So this is Kelfin versus Kelfin, Deborah Kelfin versus Judith Kelfin from 2013. What happened was dad was advancing in his age. And I guess he was kind of a domineering force. At least that's what the court case says. And had always had things a certain way. His one daughter, Deborah, was blind and I think also deaf. She suffered from significant disabilities that had progressed over time. She had a retina disease. She underwent dialysis. She had kidney and pancreas transplants. Anyway, she had a lot of health challenges and was receiving certain government benefits. All along, Dad's estate plan had included her, but at some point he changed it up shortly before death and left everything to Deborah's sister, Judith. There were just 2 daughters that he had. And he said, okay, Judith, I'm leaving everything to you. Take care of Deborah. Hannah, what happened from there that unfortunately led to this going to the California Court of Appeals?
Yeah, so clearly something did go wrong. Like we said, we're in a court case. And actually, in this particular situation, Judith did not hold up her end of the bargain. So she did not fulfill her promise to her father. She kind of took that inheritance and did not use any of it for the benefit of her sister, Deborah. So Deborah went to court trying to enforce that promise that she had made, that Judith had made to their father while he was still alive, to say, you know, my father's intention was that at least part of this money was used for me. But, you know, Judith, being the bad actor here, just kind of took the money and ran. So
now don't let the happy ending here dissuade you from doing good planning, because the jury was very generous to Deborah and ruled in her favor and awarded her $1.4 million in compensatory damages and $260,000 in punitive damages. So if it makes you feel better, warms your heart, Deborah did come away with some money, but this all could have been avoided and a lot of headaches in court if Dad had set up his will properly with the 50% he truly intended for Deborah to get in a supplemental needs trust, instead of just relying on Judith to do the right thing, and Judith did not do the right thing. So hopefully that's a good takeaway for our listeners. In wrapping up this episode, Hannah, can you just kind of remind our listeners the key takeaways in terms of supplemental needs trust planning?
yeah, absolutely. I would say the biggest takeaway is to get rid of that idea or that notion that if you do have a loved one or someone in your life that you would like to benefit in your estate plan that does suffer from some type of disability or might be applying for Medicaid or some other means-tested government program, that you do not have to disinherit them. There are options. You can set up this specific type of trust to make sure that you can leave them the money that you want to leave them without having to worry about jeopardizing the government benefits that they're receiving. And then I would say the other really big takeaway is coordinating across the board. So with your beneficiary designated assets, as well as other family members or other people who might want to leave something to that individual.
Perfectly said. Don't forget, we do have part 2 of the special needs trust planning. So stay tuned for that. But for Hannah Cannon, I'm David Shaffer. Please join us next time. Please note that this podcast is for informational purposes only and is not intended to be, nor should it be considered, legal advice. Listening to this podcast does not create an attorney-client relationship. The information discussed is specific to the laws of New York State and may not apply to other jurisdictions. For legal advice on your individual situation, please consult with a qualified attorney.